Thanks everyone. And as Teresa noted, there's kind of two parts of the agenda that have limitations and exceptions. One's the broadcast and one's the African group proposal. So I'm going to discuss here some points that have been raised or have relevant documents from the few things that we've published today and Friday. So on our working paper series, there's a section of excerpts of limitations and exceptions from different treaties over time. So I'll refer to some of those things in my presentation, but you can find the actual text in that working document. There's also a red-lined version of the new second revised draft of the broadcast treaty that shows what's changed and has some comments in the margins. Largely, the comments are drawn from that third paper, which is a paper by Professor Bernd Hugenholtz, who's much more of an expert on broadcast than I am. And I analyzed within that just the limitations and exceptions provision. And that's going to be the content I'm going to focus on here. And that's published in a blog today on our InfoJustice website. As I mentioned, there's now a second revised draft. So there was a first chair's draft at SCCR42, which met last May, I believe. And now there's a second chair's draft, and it takes out a lot of the brackets showing where the negotiations are and attempts to propose a new kind of whole text of the kind that could be referred to a diplomatic conference. One of the things that's changed in that text is the limitations and exceptions provisions. And you can see the red lines there. So the red is the information that was added. So the previous version just had those bottom two paragraphs. And that comes out of the Beijing Treaty, which is really the most restrictive of the limitations and exceptions provisions of really all the copyright and related rights treaties, at least the modern ones. And it's restrictive because it has first your enabling and then your confining. And the enabling says you may have what you have in your copyright, which by extension means you may only have the exceptions that you have in your copyright. And then in addition, it applied a new three-step test to it. So it gave a closed list of exceptions, which is just that you have in your copyright, and added a three-step test. So that means you couldn't have exceptions just for broadcast, which was in conflict with the Rome Convention, which is on the right there, which clearly said you can have these kind of exceptions in paragraph 1. Any state may provide for exceptions in the following area, for instance, private use, or one that's particularly about broadcast, ephemeral fixation by broadcasting organizations. So it was moving from that structure in Rome, which says you may have anything in this list, and irrespective of what's in that list, you can have the same kinds of exceptions that you have in copyright. So the last version was a restriction on the Rome Convention. So that received a fair amount of criticism. So I would say the intent appears in this draft to kind of rebuild that structure of the Rome Convention by having a closed list of exceptions first, and then allowing, irrespective of whether you're in that list, to open it up to exceptions in your copyright. There's a couple key differences. So first, in the first paragraph, you say, like Rome, it's permissive, so it doesn't require you to have these exceptions. It says that those exceptions must be specific, which is a word that's not in the Rome Convention. So that seems to be contrary, for instance, to the language in the Marrakesh Treaty, saying you can have general exceptions, not just specific exceptions, exceptions like fair use, fair dealing, etc. It adds quotation to the Rome list. So quotation was first added in the 1967 version of the Berne Convention. The Rome Convention written before that talked of using short excerpts. But quotation is mandatory in Berne, and you see it's permissive here. So the treaty structure would still allow you to not have a quotation right, even though quotation is mandated by the Berne Convention itself. So you could have a broadcast treaty that has more narrow limitations and exceptions than your. There's a new exception, which is quite interesting in 1E for preservation in archives. And that seems to actually be taking a page from the limitations and exceptions agenda, which, as Teresa mentioned, one of the priorities of that agenda is preservation. by cultural heritage institutions. So you see a new exception. It doesn't exist in any other multilateral treaty for preservation, and also a new exception for access to cable of certain programming signals. So that's the need that must carry. But as you look at the exception, the important thing is to notice how it doesn't include various other flexibilities that exist in the modern treaty. So for instance, the paragraphs 1 and 2 are still a closed list. You have to be either in that list in 1, or you have to exist in your copyright law, or you can't have that exception. So it ratchets down the broadcast specific exceptions to just those ones mentioned in 1. And then it uses the confining version, the WCT Article 10.2, the WPPT Article 16.2 version of the 3-step test, contracting parties shall confine. So that seems to imply that not only do you have to be a member of the closed lists in 1 or 2, but you also have to apply the 3-step test, instead of the more open 3-step test of Article 10.1 of the WCT, for instance, which says the contracting parties may in their national legislation provide it, opens the flexibility instead of confining the flexibility. So it misses that. It also misses Article 7 of the Brussels Convention, which is actually the most similar signal-based regulation to what this treaty seems to be trying to do in some of its scope of protection. But the Brussels Article 7 has a specific exception for in order to prevent abuses of monopoly. One of the more innovative and progressive exceptions that was included in the first draft has been taken out. So there was a provision in paragraph 3 of Article 12 on technical protection measures, essentially taking the agreed statement on Article 15 of the Beijing Treaty and making it mandatory. So countries shall take appropriate measures as necessary to ensure that TPM's technical protection measures don't hinder the practice of limitations and exceptions. So that was one of the area where the first draft actually went further, and that provision is removed without any. If you look through the larger number of limitations and exceptions that exist elsewhere in the international treaties, and as I mentioned, we published a paper today that just has those various excerpts. There's other limitations and exceptions provisions that are mentioned in some way in other treaties that aren't mentioned here at all. So the Berne Article 2 says you don't have to extend copyright to official publications. There are certainly official broadcasts as well. That could be something that could be named. Ephemeral fixation I mentioned, compulsory license in the Rome Convention I mentioned, abuse of monopoly in the Brussels Convention I mentioned, the agreed statements to the WC and WPPT that are also referenced in the Beijing Treaty. The current draft says that it's leaving agreed statements to the diplomatic conference, but it could, as it did with the TPM issue in Beijing Article 13 or 15, it could convert those into actual provisions. So that would be a way to take the digital rights area forward in the treaty. TPM exceptions I mentioned. It doesn't have a disability provision, and that's even though you may need to fix a broadcast, for instance, in order to create various kinds of captioning, etc. And then there's some more modern issues that have occurred in regional agreements where language could be drawn upon. For instance, the CTPP and RCEP both have a duty to promote balance, or the recent EU directives have mandatory exceptions for data mining research, and some of those exceptions are protected for copyright. So this big kind of yellow box is the area where the treaty could go but hasn't. I'll just mention very briefly, and I'm going to go fast here, a couple of issues with the Africa Work Program, just to spell out that text a little further. So I think Teresa Hackett mentioned the goal of that text appears to be to focus, as in paragraph 2, on the priority issues that came out of the 2019 action plans, including preservation, online and cross-border education and research, and some kind of protocol or something that might apply the Marrakesh rules to people with other disabilities. Paragraph 3, there's going to be some information sessions actually happening. And one interesting thing will be whether those information sessions do consider, as the Africa group proposal asks for, international models for dealing with some of the problems. And then paragraph 4 is the real kind of proposal for a process that I see as possibly trying to gain some amount of equity and process with the broadcast treaty, which has been using intersessional activities to move forward the broadcast agenda. And something similar seems to be asked for in paragraph 4 on limitations and exceptions, at least starting with principles, objectives, and modern provisions. And then some of those areas that I mentioned in that chart that have popped up in other regional agreements are included in the work plan for the purpose of studies and information sessions, etc., such as taxonomy, research, open science, contract override, safe harbor, and technical protection interests. So I'm going to end there, and just a reminder that basically everything I've said has been published today, so you can go back and find the footnotes and citations and the written version of my statements, either on the InfoJustice blog or on the PIJIP papers.